Hi, I'm Amy Bauman, Director on Aging for Piscataway Township. In this webinar, Kalea Edmundo will be presenting Planting for the Unexpected. Welcome, Kalea.
Thank you, Amy, for having me. Hello, everyone. What I'm going to do is I'm going to share my screen so you could see my PowerPoint presentation. This segment should take approximately an hour. First, I want to tell you a little bit about myself. My name is Kalea Edmundo, and I'm a senior staff attorney at Central Jersey Legal Services. I've been with Legal Services for a little over 3 years, primarily handling estate planning cases, family law, and Medicaid terminations. Prior to my time at Central Jersey Legal Services, I was a staff attorney at a Newark nonprofit for 8 years, handling exclusively family law. So with today's presentation, we are going to talk about a very, very important topic, planning for the unexpected. And the reason we talk about this topic to seniors and to the community is we want everyone to know how important it is to get your affairs in order. Planning for the unexpected doesn't have to be about planning for death. It's also about planning for your incapacity and how you want to be treated upon your death, upon your incapacity, and important issues in your life. Okay? Now, with Central Jersey Legal Services, we have offices in 3 counties, Union County, Middlesex County, and Mercer County. I am in the Mercer County office. And before we get started, it's important that I ask everybody to stay on mute. We will have a question and answer period at the end. When it comes to questions, because there's no attorney-client confidentiality, this is an open public forum. So at the end of this seminar, if you want to ask questions, please let them be general questions. I won't be able to answer specific questions to your set of facts. So for example, a general question would be, how do you leave assets to a minor child? Great, we could talk about that. That's a great question. A specific question would be, I have $50,000 and I don't want to leave the money to my kids and I wanted to go to my grandkids. That's a specific question to your set of facts, and I'm not going to answer that in this forum. All right. I will talk to you at the end about where you could get legal help, and that's really it. Now, something that's important, I really like this quote by Benjamin Franklin, but in this world, nothing can be said to be certain except for death and taxes. Both are going to happen. It's inevitable. We are not going to live forever. But what's important is the legacy that we want to leave behind to our loved ones. And that's where I'm here to help individuals. So this way, when you're making your estate plan, you're in good health, you're in sound mind, and the decisions that you make are yours and no one else's. So I like to start with a little pop quiz. I'm not going to put up a poll or a survey. I didn't do that to track answers, but just think about this. What do these famous people have in common? Abraham Lincoln, Prince, Aretha Franklin, Amy Winehouse, Bob Marley, Jimi Hendrix, Sonny Bono, Kurt Cobain, Dr. Martin Luther King Jr., Marvin Gaye, Billie Holiday, DJ AM, Chadwick Boseman, and John Singleton. I mean, I'll give everybody a hint. They're all dead. Yes, we know this, but there's something they all have in common. Could we say they're all rich? Not necessarily. You'd be surprised to learn that all of these famous people died without making a will. And if you die without making a will, your estate is now an intestate estate. So what's surprising is most people nationwide, 70 to 80% of people die without a will. That's a lot of property, getting decided by the state you live in. Intestate distribution, your beneficiaries are chosen by the state, not you, okay? So with an intestate distribution, first in line would be your spouse. next, your children. If you don't have spouse or children, then your next of kin, your parents, your siblings, etc. So boyfriends and girlfriends or charities are left out. And testancy laws don't take into account what you would have wanted. So if, for example, if your children, you wanted to disinherit them, you don't want to leave them anything. If you die without a will, you are leaving them something. So what's important in that step is you want to ensure that the people you want to leave your property to actually get it. A funny little joke I always say, my dad always says, kids never want to use their money on their parents. They always want to use their money for themselves. If you die without a will, the administrator, someone has to apply to become the administrator of your estate, and they would have to pay a bond. Bonds typically run $1,000 for every $100,000 the estate is worth. So if you have a house, you have a few assets, let's say, for example, if your estate is worth $300,000, now your administrator has to get a $3,000 bond, and the bond remains open. So you have to continue to pay, the administrator would have to continue to pay the bond every year until the estate closes. So if you don't want your kids to pay administration fees, do a will, okay? I think that's the most important thing. Now, why do we want to do an estate plan? Like I've been saying, an estate plan puts you in charge of your assets and your health care decisions, what you do with your money, who you leave it to, who's managing it. You don't want to leave these things to chance. It puts assurances that your wishes are followed the way you want them to be followed. And it takes the decision-making away from your family, because sometimes, as good intentioned as family are, they're not necessarily going to do what you want, okay? So that also is very, very important. Now, I have another little pop quiz, and I just want you guys to answer this internally. Who has their estate plan in order? So who has a will, a power of attorney, advance directive? If you do, that is fantastic. I still want you to stay, because I always tell people, when there's a significant change, like for example, let's say you've reached a new decade, or you recently found out that you have a serious illness, or let's say if you had someone die who was close to you, you can always update your estate plan. It's not something that, okay, I wrote it 25 years ago and I can't change it now. It is what it is. You can always change it. Please don't change it every week, because some lawyers, we don't like that. But, especially if we're talking about 10, 15, 20 years, you want to look at it again and make sure it's still current. Sometimes beneficiaries, die before you. Sometimes things change. Okay. And with writing a will is a privilege. This is something that we're not forced to do, but we have a right to do. Now, when you make your will, there's a couple of key appointments in the will. And the key appointment, the first one is you need to appoint an executor. I want to add a little caveat in here that for executors or executrix, so it's either or, I'm usually just going to defer to saying executor, but with an executor or an executrix, this should not be a surprise appointment. This is not something you want to spring on somebody and they find out after you're gone. You want to have a conversation with them saying, hey, I did my will, or I'm going to do my will, and I would like you to be my executor. This means that with the executor, this is the person who is going to collect the will, marshal your assets, find any important documents, and file your will and death certificate with the surrogate's office. There is a filing fee. Within your will, you could waive the bond requirement. So this way they don't have to get a bond to secure the estate. And after they have done that, then they would notify your next of kin. The executor has the job of ensuring that any debts against the estate are paid before any assets go to next of kin. Also, when we're talking about a will, another key appointment inside of your will be appointing a funeral agent. Now, people hear funeral agent, this is the person who ensures that your wishes are followed in regards to, do you want to be buried? Do you want to be cremated? Do you want to donate your body to science? The executor and the funeral agent can be the same person. And honestly, you could appoint the same person or not, or different people. The funeral agent is not going to use their money to pay for your funeral. I want to make sure I put that out there. They are going to request the funds from the executor from your estate. What I always tell people is, if you have some funds, consider pre-planning your funeral. With the funeral home, you can have a prepaid funeral trust set up through NJ Cares. You can ask the funeral homes about it. It's a contract. The money gets put into a trust that is held by the state. You don't want to just prepay a funeral home and you give the check, make it out to whatever funeral home, because what happens if the funeral home closes? That does happen. At least when the money is paid into trust, that you could be assured that that money will be there for how you want your remains, burial, cremation, anatomical gift. Before we go on the type of assets, also with a will, when you're making the will, you are the testator or the testatrix. One of the things that we look for is you have to have testamentary mental capacity. So what I'm looking for when I meet with clients is, first, do you know who you are? That's very important. You know who your natural objects of one's bounty. That's your relatives. If you come in and I meet with you and I start talking with you, and, these are different examples of what's happened, either you don't recognize your loved ones, you don't know who they are. I've had clients where I've met with, I'll ask them, who's the president? And they tell me Ronald Reagan, so what we're really looking for is, do you have the capacity to do this? Do you know what property you own? And not just physical property like a building, I mean assets, bank accounts, things of that nature. And really the ability to understand who you want to leave the assets to, and if the plan that we work out together will work. So if someone, because really the purpose of the will is to talk about or make the plan for disposing of your assets, not throwing them away, leaving them to particular individuals or not, or charities. So that's what I'm looking for. When I don't see that, or when I see someone really can't understand, especially like, for example, if somebody comes to my office and I sit down, I tell them I'm a lawyer and, I'm here to talk to them about what they want. And then I start talking about estate planning. And then after all of that, they think they're at a doctor's office. That's a problem. Okay. And then that's when I will usually pull the loved ones in. So it's just something to be aware of when you meet with an attorney to do your estate plan. They're going to ask you questions that may seem personal in nature. It's just they are trying to gauge or figure out, do you know what you're doing? Okay. Now, there are two types of assets that are in it. There are two types of assets that usually everyone has. There's probate assets and there's non-probate assets. I personally like non-probate assets because they do not flow through your will. They go directly to the individual who is listed as the beneficiary. So since they don't flow through the will, they don't have to go through what a probate asset would go through, and I'll talk about that. So non-probate assets are for retirement accounts, life insurance policies, maybe property. So let's say if you own property jointly with someone else and that property has rights of survivorship. So for example, you and your husband own a house together. House says husband and wife on the deed. In the event one of you dies, the house will pass automatically to the other spouse. But you still want to do an estate plan anyway. you and your spouse, because what happens if, God forbid, both of you die from the same tragic incident, accident, whatever? So that's just something to keep in mind. Even if you have non-probate assets, you still want to have that will, because the will talk about what happens almost as it's like a fail-safe. Now, with probate assets is property that you own as an individual. I'm a single gal and I own my own house and nobody else is listed on the deed but me. These assets flow through your will, and it includes tangible personal property. So, for example, bank accounts, securities. Sometimes you may have, you don't have any assets, but upon your death, there could be assets that trigger an estate, like a wrongful death suit. So even, I don't want people thinking, oh, you have to have hundreds of thousands of dollars to make a will. If you have any asset of any amount, I really think you should talk to an attorney just to think about making a will. I don't like when people are told, oh, you don't have that much to leave anybody. Well, I mean, that's at this point. What if you hit the lottery tomorrow? Then what will you do? Okay. Now, what's important is with probate assets and non-probate assets, especially when you own property jointly with another individual. So let's say, for example, your spouse. Even if you put in your will, I want my house to go to my daughter, if your spouse is still living, the deed will always trump the will. So it always goes back to how the deed is written. If you have a deed and let's say you owned your property with your spouse, pull the deed out and look at it. Because if there's any corrections that need to be made to a deed, do it now. Now, sometimes I have clients ask me, oh, should I add my child to my deed? Not unless you want that child to inherit a 50% share upon your death. So for example, and I see this a lot, mom and daughter will have a house together. It'll just say joint tenants. It doesn't say with rights of survivorship or anything like that. So the 50% upon mom's death, 50% will go to a share will be the daughter's house, but then the other 50% share has to go through the probate process. So if there's other kids and there's no will, they would actually have an equitable, they'd have a right to inherit mom's 50% share. Don't add all this confusion in your life. Don't add a child onto your deed for the sake of, hey, I'm going to, that's okay, it's just my husband, he's bringing my coffee, thank you. Don't add your child onto your deed for the sake of, hey, I want to make sure that this goes to somebody. So really, estate planning is individual to the person, and you want to talk to an attorney about how you're going to do that. And also, all assets are not created equal. So for example, annuities, some assets are only one generation, and it doesn't necessarily pass on to your children. So you want to check that. It's the assumption that your spouse may get the rest of the annuity, but please check. Don't assume anything, just check. And sometimes a simple phone call to the annuity or to the bank or what have you. If your only asset is a bank account and you don't own any property, you don't have anything, what you can do, and I always say this is like our poor man's version, is you can not add somebody on your bank account as a co-owner, especially a child, because sometimes kids have debts they don't want their parents to know about. And then one day the creditor gets a little bleep on their system, hey, there's a bank account over here. Because then that creditor will think that account is your child's and start garnishing it. And for seniors, many of the sources of income, like Social Security, retirement, are judgment proof from a creditor. So you want to be careful. What I say you could do is you can ask your bank, making your account payable upon death to a particular individual. That you're allowed to do. It's called a POD account. So that's just like a little tip if you're concerned about it. All right. If you are going to disinherit someone from the same, like for example, if you only have children, you have no spouse, and you decide, my two oldest children, I want them to inherit my estate, and my two youngest children, I want them to not inherit anything. So if you are disinheriting someone, especially if it's from a group that is otherwise would have inherited, it's important that your will have language to specifically disinherit them. Because if you don't, what that person could do is they can later contest the will, right? And with a will contest, they could bring up, hey, mom, I wasn't even mentioned in mom's will. And obviously this was a mistake because my other two siblings were mentioned and me and my other sibling were not mentioned. So that could be one reason. I also think that it's important that you don't want it to seem that a relative who's in the line of succession was accidentally forgotten or left out. And if you are going to disinherit someone, this is just a practice tip for me. I ask my clients, like, if you're going to disinherit a child or whoever, in the will, I'll put something like, it depends on what it is, the reason, but let's say you just want to help your other child out, or let's say you were estranged from your child. We could put nice language in so it's not, you were a bad child, that's why I'm not leaving you anything, because nobody wants to leave that behind as their legacy. We usually put things not for lack of love and affection, but we want to benefit the other children. Write a letter that could be, and it won't be part of your will, but write a letter explaining why you're disinheriting the child. Myself, I like to make copies of those letters and put them with my clients' files. So this way, if we have an angry child that comes back later, I could read the letter. But also, you take the original, we put it in an envelope, I seal it, I have you sign the back of it. Because I think that's important, because sometimes as a parent, your child may have already inherited, and if you want to be fair, explain it. And I don't see any harm with that. And I also tell my clients, by the time it gets read, you won't be here. So it's like, who cares? And in your way, you have the last word. So I think that's important. But who are our next of kin? So I have a listing: spouse, children, grandchildren, siblings, nieces, nephews, friends, parents, and charities. Or even Marta Cabrera, who was I think she was the nurse aide for the decedent. So, that's something that's important. You could leave your property to who you want in your will. The only thing that I ask about is that, whoever you leave your property to, you really thought about what you want. Because as a practitioner, what we don't want is 1 week you say, disinherit my 2 kids. And then 2 months later, you made it with your kids. Oh no, I need to change my will. And you need to drop everything and fix it. It's kind of like, it's not a one-shot deal. It's a living, breathing document. But we kind of would like to make sure that these are your final wishes, because when you start making changes and having different revisions to wills, and it starts to look a little strange, okay? Now, this is always the fun part. The surviving spouse, is entitled to what's called an elective share. So let's say you're separated from your spouse, right? Or let's say you don't have a will, or you want to disinherit your spouse. Your spouse can make what's called an elective share to obtain 1/3 of the augmented estate. So that's your estate minus any debts and encumbrances on the estate. And then after that, they'd be entitled to 1/3. But it's the spouse who needs to raise this argument. Now, if you're divorced from your spouse, you don't have to worry about that. That's fine. They're not going to inherit. It's important if you're legally married and separated. I mean, the spouse would need to prove, that they were cohabitating with you and still together as a married couple. So there's evidence they would have to show to prove this. So it's not automatic. But if you are separated, not yet divorced, you haven't had a divorce by bed and board or an annulment, it might be something to consider. Think about the divorce. I know a lot of people feel like, oh, why bother? I don't want to be bothered. I've been separated for like 40 years. Well, why stay married, any longer? They've been separated 40 years. It shouldn't be a big deal. Okay, so next part, do we dispose of our assets in our will? So sometimes we can have a specific bequest. I want my car, my house, my cat to go to specific people. And just an FYI, if you are leaving a pet to someone in your will, you definitely need to have a discussion with them. I've done a couple of wills with pets, and if you want to ensure that the pet is going to go to the loving home you want it to go to, please talk to that person, because then there has to be provisions made to care for the pet. It's a big undertaking. Pets cost money. There's vet bills, there's food, medicine, the whole thing. It's like another child. So that shouldn't be sprung on somebody as well. So with a specific bequest, we could put that in the will, or you could leave and say, I want everything that I own in the world to go to these particular individuals, one individual or a charity or what have you. If you don't want to do a specific bequest, you could do what we call a personal property memorandum or letter of instruction. It's outside of your, it's what I like about the personal property memorandum, you do have to make reference to it in your will. So that's important. It would say something like, I have a letter of instruction on specific items that I want to leave to particular people. And this is where you can leave the items of sentimental value. I tell my clients, have fun. I'll type up whatever you give me. It's fine. And they would sign it and date it. You know, things like my engagement ring, or, you know, my dishes that I have, my, you know, silverware, or my wedding dress, whatever it might be. If you want to specifically leave it to someone, that's great. And what I like about the memorandum is if a client wants to change it, they can just rip it up, write up a new one, sign it, put it in another envelope, put it with the will. So I think that that's important. The memorandum doesn't have to be witnessed. My office, we just witness them because we're there anyway. But it doesn't need to be witnessed, but it's important that that memorandum stay next to your will. So when you have a memorandum, I tell people, you know, complete it, put it, I make a copy for my folder, for my files, and I usually type them up for my clients, and then put it in an envelope, seal it, sign the back of it, and this way, it's another letter of instruction that will be stored with your will. Another way to leave property to someone is a testamentary trust. So the trustee who you name, and also plan on, for all of these appointments in here, always plan on alternates. I can't stress that enough, because people die, they move, they fall out of grace, whatever it might be. So always have a backup. But with the trustee is the fiduciary. This is the person who's responsible for holding the money in trust on the benefit of someone else. And it can only be, well, for the purposes of your will. So like, for example, you want to leave property to a minor child, right? That has to be done through a testamentary trust in your will. There are other types of trusts outside of the will. We don't do trust work at my office. I mean, we'll put a testamentary trust in a will, but we're not a firm that creates these things. We're a nonprofit organization. So many of our clients have limited assets and resources. But what's important with the trustee, they can only distribute the funds in accordance to the benefit. They can only distribute the funds in accordance with the terms of the trust agreement. So for example, if you say, I don't want my grandchildren to get the money until they're 25, and I always love that number 25, then that's what they have to do. Or if you say it's for this purpose or that purpose, I really don't like to say for their education, because some grandchildren may decide, I don't want anything more than high school. I think an older age than 18 may be good, because if an 18-year-old, let's say, inherits money, may not be as mature with it as you would have hoped, and maybe 21, 23, 25, when they've had some time to understand the value of a dollar, it would be more beneficial to them. Okay, so that's just a thought about it. So there's the trust for minors, but then there's also a special needs trust, and that's for disabled adult children. And it's important to create this if you have an individual who you're leaving property to who's permanently disabled and receiving Social Security SSI benefits. Because if they just outright inherit the money, what's going to happen is they're going to get kicked off of SSI. They could lose their SSI, they could lose their Medicaid eligibility. The money, when it goes into a special needs trust, would be used to pay for extraordinary expenses. So, we can't say, oh, we're going to use it for their rent, but could they use it for their vacation or to buy themselves, like, to go to the hairdresser, get their haircuts, buy, trying to think of something that I'm trying to remember something, maybe buy additional services for them, movie trips, things of that nature, items that wouldn't be covered under their SSI. And then the money with the special needs trust, it would be solely for the disabled adult child. And then let's say if the disabled adult child predeceases you, then at least that money could go back into your estate. So with anything, you always want to think about plan on alternate beneficiaries, because like I said, people die or move away or whatever it might be. Okay. And sometimes beneficiaries can refuse a gift under the will. So that's something else to consider. Oh, and sorry, there was another slide that I didn't realize that was there. Okay. Now, when it comes to making a will, there are some legal requirements that must be done in order for the will to be valid. So first, we need to make sure that the testator is over the age of 18 and of sound mind, and that nobody's forcing you to do this, and that you're doing this of your own free will. So that's very important. So I always ask clients, because I work primarily with seniors, are you over the age of 18? And I get more giggles and more laughs and snarky comments. But I do have to ask, yes, I know you're over 18, but that's one of those dumb questions, just so this way we could preserve, like, yes, I did my job and asked everything on my checklist. Now, the witnesses, wills must be witnessed in New Jersey. So your witnesses also must be over the age of 18. And they also must be of sound mind. And yes, have I gone to signings where I was questioning the witness and then stopped the signing? Yes, I did, because pre-COVID, we would do signings at seniors' houses for seniors who were homebound. But now, because of COVID, we are not doing any in-home signings. We're doing primarily most of them virtually, and I'll talk about that. There's no prohibition about beneficiaries witnessing the will or acting as witnesses, but I'll be honest, as someone who, this is one area of law where there's a lot of malpractice. I'd rather not have your kid who's inheriting everything be one of your two witnesses. We typically, for my office, we provide our own witnesses unless we're doing a virtual signing. And now in the time of COVID, we're just happy to get any witnesses, especially when we're doing virtual signings, that we can. Now, for a will to be self-proving, the witnesses verify that they saw you signing the will and that you made the will voluntarily and freely. And this self-proving statement must be signed by an attorney or a notary. So all wills aren't self-proving. If the will is not self-proving, and let's say the will is contested, then the witnesses would have to appear in court to testify as to their presence and what they saw. If a will is self-proving, thankfully your witnesses would not have to appear. And that gets hard because witnesses, like I said, they die, they move away, they lose contact, you might not be able to find them. So if you're going to do a will, please do a self-proving will. I think that would be the best thing for everyone. There are other types of wills, like holographic wills. It's a handwritten will that's signed by the testator. I'm not talking about that because my office, we don't do them. And sometimes you can have writings intended as a will. Those have to be litigated, and there has to be clear and convincing evidence that the testator intended that writing to be their will at that time. Again, My office, we don't do any probate litigation. You'd have to go to a private firm for that. Okay, now let's take a look. I'd like to talk about the power of attorney, but before we go to power of attorney, if anyone has any questions in the chat, or if, let's take a look, I can't actually see the chat. If there's any questions regarding the will process that I was just talking about, oops, I think I did something here. Okay, oh, that was me. Any questions in general about the will? I mean, we will have time at the end to ask questions as well, but I just wanted to put that out there. Okay. All right. Well, if not, I can move on to the section about the power of attorney. Power of attorneys are actually my favorite thing because this is a document, the power of attorney and the advanced directive for healthcare. Whether you have assets or not, everyone should have this. Okay. A power of attorney is important because in this power of attorney, you as the principal are appointing an individual to act as your agent. And the agent of the power of attorney has the ability to make financial decisions on your behalf as you would do for yourself. So I think it's important to have this because many people are under the confusion that, oh, I don't need that. I have my spouse. They can make decisions for me. Unless they are specifically given the legal authority to do so in a writing, no, they don't. So if you have a checking account that's just yours, I have clients where their spouses and they each have separate accounts. If you and your spouse have separate accounts, just because you're married to that person at the time you become incapacitated, doesn't mean they could go and access your bank account or do your banking or take money out of the account. So rather than wait for something to happen, why not have the power of attorney in place? I think what happens is people think if they sign a power of attorney, that means they have no more decision-making authority and everybody's going to come in and do whatever they want and they're not going to do what I want. As long as you have capacity, the buck stops with you, okay? So if your agent is doing something that you don't agree with, you have the right to agree, disagree, change anything that your agent is or is not doing. So if your agent says, hey, I want you to move to this other nursing facility, but you like the nursing facility you're at, you're in assisted living, you stay right there. You don't have to go. Now you need to make sure you have the money to pay for it, but it's your life. These are your choices. When the agent makes decisions that, you know, what's important is you want somebody to make decisions in the event you can't for yourself. And when you make the power of attorney, it's not like you have to hand it over. You could just tell them where it is in your house. They have to have it to use it. So that's the other thing. You don't have to like give it away. And I do not believe in making copies. If you have your original and you have one copy, that's it. Everybody in the family does not need a copy. And since we're talking about family, you know, if you don't have this power of attorney and this is a non-joint account and it's, like I said, a solely owned asset, if you don't have it, then the only way they're going to be able to obtain your assets or to handle any of your assets or finances is to obtain a guardianship of you. And that's an expensive and a long process. It's not cheap because they would have to file a petition in court asking to become the guardian of the person and or property. And that would be you, of the incapacitated person. And they would have to pay legal fees for you as well as for themselves. So, you know, as far as guardianships are concerned, many adults who become incapacitated, that whole process could have been bypassed if they had a power of attorney. It's another thing if you have an adult disabled child, because that child never would have capacity to give you a power of attorney. But when you're an adult and you're in good sound mind, I don't know why you wouldn't have the power of attorney. Now, what an agent can do for you is they are known as your attorney in fact. So they can't represent you in court, but they can hire an attorney for you. The agent has a fiduciary duty to you. So that's a duty of care. And you want to appoint a fiduciary who is a trustworthy person. This is when I have my clients and they say, oh, I want to pick my son. Okay, let's talk about your son. I know everybody loves their children or their nieces or their nephews or their grandchildren, But just because you love them does not mean that is the person that you should pick. Some children have financial problems. If they can't even balance their own checkbook, why in the world would you trust them with yours? I think this is important. It's a thankless job. It does not mean you love somebody because you pick them to be your agent. You want to pick the person who is going to get the job done. I will ask clients about, like, okay, so for your child, did they do bankruptcy? Do they do this? Do they have credit card problems? Because people are well-intentioned. And let's say if their back is up against the wall and they have their own issues, sometimes your money, they may want to borrow it, right? And then put it back or take it. And I've done a couple of revocations where that's happened. So don't pick someone because you love them. Pick someone because it's great if you love them, but pick someone who you know is going to get the job done and make the tough decisions and not use your money in an inappropriate way. This is something you don't want to spring on somebody. They should know, because they need to understand when they're handling your money, how you do it and what your expectations are. And power of attorneys don't expire in New Jersey. So they only end at your death or if you revoke it. And like I've said, I've done a couple of revocations. So it's just important. Now, to do a power of attorney, you have to have the capacity, the mental capacity to contract. So you, as the principal, must possess sufficient mind to understand in a reasonable manner the nature, extent, character, and the effect of the act or transaction in which you are engaged. So if you do not have contractual capacity, then you cannot sign the power of attorney, and I wouldn't sign it. And like I said, you as the principal have the right to contradict or override the decisions of the agent, all right? The only time the agent's decision could not be contradicted is if you were found to be mentally incompetent. Now, there are two types of power of attorneys. There's a power of attorney, if you sign it, it's effective immediately, or the power of attorney doesn't go into effect. It's a springing power of attorney, where it only go into effect if there's a qualifying event, such as a disability. Now, me personally, I'm not crazy about springing power of attorneys. I have prepared them because a bank, when they see it, they have to get the doctors. So there has to be 2 doctors to certify that you are disabled and unable to make decisions for yourself. Well, the banks being the banks, this is giving them too much decision making. We'll look at that doctor certification and say, hey, I don't like that it's on yellow paper. It needs to be on purple paper. Or I don't like how the doctor said this, or the doctor didn't specifically say this laundry list of things. Here, take this and go back to the doctor. Doctors don't like filling this stuff out. They really don't. Not for a power of attorney. Guardianship, they understand. There's a specific certification they have to do. But for something like this, they don't really want to do that. So I think springing power of attorneys give too much oversight from the bank. Too many delays could come as an effect of it. And at the end of the day, even when you bring the certifications in, the bank doesn't have to honor it. They do have to honor that immediate power of attorney, which is effective upon signing. If you are concerned about having an immediate power of attorney, like I told my clients, keep it in your house. Just let the agent know where you keep it. And if you're that concerned with the agent, then maybe you need to have a different agent, and that's where I would have that conversation with my clients, saying what's going on. Now, with an agent, they can handle your bank accounts, including opening or closing it, writing checks, collecting money owed to you, prepare and file your tax returns, buying and selling property on your behalf. And I would say when you have your agent, appoint an alternate. Now, you can have co-agents, but like I tell people, why would you want to have that type of chaos in your life? Because either the co-agents would have to work in tandem, so they'd have to work together and agree on everything, or they can work separately. But at some point, they're going to bump heads. And I know people will tell me, oh, but I want my kids to work together. And I'm like, no, not on this, you don't. Because then if they can't work together and a decision has to be made for something, now you're forcing your kids to litigate and go to court if they can't come to a decision. You don't want that. I was like, you pick one person and then an alternate. So this way, when the one person can't do it, then you can have an alternate. I've had a client before with co-agents, and I'm like, I make sure to write my nice little letter. So you really, again, this is not about your kids working in harmony and working together. It's appointing the correct person who's going to get the job done. So what I always say with clients as a tip, what you should look for in agents are someone of good character, someone with good financial skills, good organizational skills, someone who actually has a personal relationship to you. Are they willing to serve? Do you perceive any personal challenges they may have? And, really, can you talk to them about your expectations? All right. So I just think that's also very, very, very important. My little tip is once you have your power of attorney, please don't put it in a safe deposit box, because if you put it in a safe deposit box, the agent needs a power of attorney to get it. The bank isn't going to say, oh, we'll open it for you to get that document out. No, they're not. They're going to say, go get the power of attorney, and they won't be able to get it because it's in the safe deposit box. You can put the will in the safe deposit box, that's fine. But the power of attorney and advance directive, please don't put that in there because no one will be able to get it. Advance directives, also known as the living will, and this is why it's important. So, per New Jersey statute, you would retain all decision-making regarding your health as long as you are able. Your medical proxy would only come into effect in the event of your incapacitation or inability to make medical decisions for yourself. So they're not going to just, I have clients who worry about filling out a living will because they say, I don't want anybody pulling the plug. Nobody's pulling a plug, okay? It's very important. There's not going to be a plug pulled unless it's something you wanted. Now, and even before they pull the plug, they have to have your treating doctor and another medical professional determine that you are not able to make decisions for yourself, that you're incapacitated, and that the proxy, this is the person you appointed to make that decision for you. The proxy has to follow the living will that you prepared. So in your living will, if you said don't pull the plug, well, the proxy shouldn't be able to jump in and say, oh, I'm going to pull the plug now. The doctors aren't going to allow that. And before they would let the proxy make decisions on your behalf, your treating doctor and another medical professional need to make that finding of incapacity. And then they would put that documentation in your medical file. So nobody's going to, pull in a plug and all of this other stuff. Another reason why a living will is important, and there's forms that you could get, so there's the 5 wishes form. I think it's from Good Samaritan. You could just Google that. Attorneys, we prepare living wills, and the state of New Jersey has a New Jersey Common Form. It's, the Common Form is free. 5 wishes, I think they charge a couple of dollars, like $8 or $10 for their form. Or if you email Good Samaritan, I found this on their website. If you email them, they will send you a free copy, which I like too. Or if you have an attorney prepare your living will. I don't know what rates attorneys charge because for my organization, the seniors who we represent, our services are completely free. But what's important with this living will medical proxy is you could assign if you want to donate your organs, you can address any significant health issues, and you can appoint a medical proxy. And why you want a medical proxy is they would receive the same information as you do. They would confer with the medical team, review your medical chart, ask questions and get explanations, discuss treatment options with medical professionals, request consultations and second opinions, consent or refuse medical treatment or test on your behalf, including life-sustaining treatment, and authorize the transfer of you to another physician or institution. So let's say if you're in the hospital and the proxy doesn't feel like you're getting the care that you need, they can have you transferred to another hospital. I think the key with planning this living will is to avoid conflicts with family members, and it lifts a burden of uncertainty for people. So, like, for example, you may want to say, I want to pull the plug, right? And then your kids are like, no, we have to keep dad on life support. Well, this is why you want to have a proxy who feels the same way that you do. Again, it's taking that decision making away from your loved ones, and it's making sure that your wishes are followed. You want to appoint a proxy who is likely to follow what you want. You want to talk to this person about what your expectations are for your medical care. And you want to make sure there's someone who's good at asking questions and getting information, and who's emotionally capable of fulfilling the role. Okay, so that's another thing. You could spell out what you want, or you could just have what's called an instructive directive, which is basically an appointment of, this is my medical proxy. They know everything I want, and it doesn't specify anything. But if you do the instruction directive, you really want to make sure you've had that conversation with that person. Like, you guys need to go have a cup of coffee or some lunch or something and go over all the details. Okay. Now, in here, and also for all of your estate planning, you really want to update it every 10 years. You know, look at your estate plan. If you have a medical proxy, if it's a new decade, if there's a divorce, if there's a death of a loved one, if you receive a diagnosis of a significant health condition, or let's say if you experience a decline of your functions, or even if you move to another state, that's something you want to think about. Now, there is a question in the chat that says, POA has fiduciary duty. What if the POA neglects, avoids the represented individual, and the individual has no one else to be power of attorney? So this is a hard part. So first, you want to get that revocation done that I was talking about earlier, because if your agent, the agent of your POA is not doing their job or mismanaging your finances, you need to get them out. That's the important thing, and get that revocation filed with the county clerk's office. Let's say if you own any property, because power of attorney has the authority to sell property if you own it. If you have no one else, this is tough. I always feel like somebody may have someone. I mean, I've had clients where they truly didn't have anyone else. I mean, you know, there are, I believe, banks that could act as a power of attorney, or attorneys, but, you know, I wouldn't be comfortable myself being a client's agent or the power of attorney. I don't even think it's allowable. I know there are different services that assist with, like, let's say if you just need help, like managing your finances or balancing your checkbook and things of that nature. Sometimes if you have a trusted friend or a neighbor, if you could talk to them and trust them, but, you know, it really is going to depend on you. Sometimes members of the clergy, if you're part of any religious institution, you could talk to them about it. But it's a big undertaking, because, like I said, being the agent of a power of attorney is a thankless job. Not only do they have to manage their checkbook, now they have to do yours too. So it's something that you want to think about. I hope that answered your question. I know it's probably not exactly what you wanted, but that's the best advice that I could give in this forum. Okay, so let's start talking about, so if you need help, our office, like I said, we're in 3 counties, but the Middlesex County office, they don't do the same estate planning that we do in the Trenton office. So if you are someone and you need legal help and you want to talk to an attorney about your options, there is the Middlesex County Bar Association. They offer a lawyer referral service. I have their information up here. 732-828-0053, extension 100. I'm actually going to type in to everyone the phone number for the Middlesex County Bar MCBA lawyer referral service. Okay, I'm going to put their phone number in the chat. So this way, if you want to copy it, there are a lot of attorneys who do estate planning. Something that I would say, if you end up retaining an attorney, a good question to ask them is, how many wills have you done? Or do you have references? Or how long have you been preparing wills for individuals? Because there are some lawyers that, they prepare wills, but if you need something more complex, you need an estate lawyer, you need especially if you're looking for Medicaid planning or trust planning, you want to find an attorney who does that. Now, this is the information for our offices. And as you see, we do have an office in Middlesex County in New Brunswick, but they don't do all of the estate planning, like I said, that we do at the Mercer County office. Okay, now, something that I know we're probably close to out of time. Amy, how are we doing on time? Because I have 5 more minutes, or do you think we're at the end? Okay, so what's important, especially right now in the pandemic, is to be mindful of scams. There are scams out there targeting seniors like you wouldn't believe. Internet scams like saying, oh, grandma, I've been arrested. Don't tell mom. Go get a gift card for $500 and send me the number via Facebook. If your grandchild has been arrested, the likelihood that they have their phone is slim to none. Call your kids and find out if your grandkid was arrested. Or a long lost love who's overseas needs money to get home. PSEG, like most utility companies, have to send you a written notice before the disconnection. So the fact that they would call over the phone saying, your services are going to be disconnected right now. No, that is not going to happen. That is somebody trying to shake you down for money. I tell a lot of my clients, if a number comes in, if you have caller ID and it's a number you don't know, you don't have to pick it up, send it to voicemail, they could leave a message. I know sometimes tragedies happen and it might be a phone call from a hospital and you're concerned and everything. If you are concerned, pick up the phone. But if they start saying, oh, we need money, or it's the Medicaid, or it's the IRS and you owe us money, the IRS will send you a letter. And they don't call you unless you've called them first. So be wary of these types of scams. If you want to report scammers, and I can email these phone numbers to the Piscataway Senior Center, you could report them to the Federal Trade Commission, also the New Jersey Department of Consumer Affairs. They have an 800 number where you could report this, especially if you're a victim of this fraud. If you've already lost money because of one of these scams, you can also contact your local police department. So it's just very, very important. I had a little video, but I'll skip it because I think we're almost out of time. As far as the vaccine, if there's any senior 65 and over who wants to be vaccinated and you have not, and you're not able to get signed on online, or know a senior who can't get signed on online, seniors only could call the New Jersey COVID call center hotline at 856-249-7007. They will get you registered. You have to be over the age of 65. So this is a great service, and I say all seniors should take advantage of it. Okay. And just some other tips with the fraud going on. You want to protect your money. So this real seminar is about planning for the unexpected, but also protecting your money. Okay. Stimulus check fraud is going on. There are smart ways you could use your stimulus money for yourself and not for other individuals, unless that's what you want. Like, for example, if there's medical equipment or anything that you need that's not covered by Medicare or Medicaid, that's what you could use your stimulus money on. Medical insurance. So New Jersey expanded the enrollment period for health insurance. So if you need Medicare and you do not yet have it, I would say get that application done, because if you have a period of time where you are not covered by any insurance and you are eligible for Medicare and don't get it, you will be penalized. So this is just some important tips. Okay, well, this is my contact information. If you wanted to send me an email, that's fine. And if somebody has a question that they want to ask or unmute, I'll hang around for a couple of minutes.
I have a question.
Oh, yes.
Uh, what's the average price of, let's say, an average will?
I have no idea. I work in a nonprofit. I mean, I would think, I have no idea.
Oh,
I mean, I know other attorneys in this area. I mean, I've heard of wills being $1,000, $500, $2,000. Because it really depends on what are you getting. Are you having a simple straight will? Are you getting a trust? Do you need to do a special needs trust? So I would say call the Bar Association. They have a lawyer referral service. And I believe it's $25 for the first 30-minute consultation. And then that's what I would do, and call them and just get the consultation. Sometimes, trying to think, like I know there's wills for heroes, like if you were prior service or police, I believe those are being done for free. I'd love to see like a program that, if we can have something statewide that cater to seniors, but that's, in the works, I think, for hopefully for the future for an organization. But I would just say call. And if the first lawyer you meet, if you don't like them, meet with another one. There's so many lawyers in New Jersey. I think there's over 80,000. So
thank you.
yeah, you're welcome.
And,
Other questions? Okay, well, if there's no other questions, I guess, Amy, do you want to do any closing
I just wanted to
remarks?
say thank you, Kayla, for all this information today. I think it was very informative, and we appreciate you taking your time.
Oh, no problem. And thank you for having me. I really appreciate it. I love talking about this topic. And I hope you guys, I always say knowledge is power. So take the information you learned and share it with someone else. I think that's the best thing anyone can do. All right. Well, I guess
Okay. All right.
thank you. Bye,
Thank you very much.
everybody.